And with that, we'll open it up for questions.
The right of self-determination never came up. As I understand it, one of the principles is that nobody can force the native population of that territory out of that territory or divide that territory. As I understand it, the Palestinians have never agreed to have their land divided. On what basis did the United Nations make that division?
That's a really good question. And in fact, of course, it goes back to Resolution 181. And that was a very interesting resolution because there were actually two proposals that were put to the UN at the time. One was a single state with separate institutions for the two communities. And the other was the division of territory. Now, the General Assembly, as you point out, had no authority to divide land. The General Assembly has no such power. So 181 is legally viewed as a recommendation to the parties. And if you read 181, again, it's a very interesting resolution, both for what it did, but what it also did not do, because it had to tread a very fine line between being consistent with the UN Charter, which would require equal rights for all of the people in the territory, and yet try to accommodate the demands of the Zionist presence there.
There's a political background to it.
There's definitely a political background. But very, very briefly, 181 did not authorize, that's why I say this in quotes, Jewish and Arab states. It actually didn't authorize a Jewish and an Arab state. It talks about the two Palestinian peoples, and the Jews who were going to be granted their state were those who were habitually resident in Palestine, part of the Palestinian territory. There is nothing in Resolution 181 that authorizes recognition of a Jewish population that can claim extraterritorially rights to that land. And there's no UN resolution subsequent to 181 that does that either. So 181 is a very thin basis for claiming the right to a Jewish preferencing state. It's not there. One of the criteria, there were a series of criteria built into the resolution before the two states could come into being. And the UN was supposed to carry out a supervisory role for a full year, during which time both entities were supposed to draft a constitution with equal rights, non-discrimination, and the right of anyone from either side to choose where they wish to be citizens. None of those criteria were fulfilled when Israel claimed its state. The delegates to the UN, the Arab states, tried to take the legality of 181 to the International Court of Justice for an advisory opinion, and they were defeated in that effort. So we don't really know. We have no ruling from the World Court about what the legality is for that.
Thank you.
Of course.
Sir.
I wanted to know if any development or moving forward with Palestinian refugee rights would weaken the momentum of the right of the return, because Palestinians would be somewhat comfortable in the states where they are refugees. Would that weaken their need to go back to Palestine, other than their obvious connection and nationalism and everything, all of that?
So there's a lot of questions in one, actually. And one of the things we didn't do was to separate out the different aspects of the rights that the Palestinians have. So return is separate from property restitution and separate from compensation. All three are obligations and entitlements. But for example, the best way to answer that is in other mass refugee solutions around the world. And we've seen this in particular since the 1970s, because the international community has become more sophisticated about how to incorporate these universal rights into refugee solutions. So because return, absorption, and resettlement are at the voluntary choice of the refugee, it starts with, what does the person want to go home? And so that's the fundamental bedrock right, because that also has that obligation on every state to implement that. Once that's determined, then the question of property comes into place. Does the person want restitution of title, the actual property? Are there secondary rights of occupants? All of those have a set of laws governing whether there are conflicting rights there. So we haven't really talked about how that would work. In other mass refugee flows, people have, first of all, it's driven by the return, and then individuals who are in second or third states make their choice. If those states are willing to accept them, they can remain there. They can still get their property back. They can get their title back. They can move back, come back and forth as they choose, depending on the documents or citizenship status that they have. That's not inconsistent. If they choose not to return, they can still seek compensation. So these are separate clusters of rights that need to be broken down and understood, but there's no mystery. We have now 60 years of experience in mass refugee situations all over the world, and there's something called comprehensive plans of action, which look at all of these different obligations of states involved and the different categories of individuals who are making different choices. That's why voluntary choice is at the heart of refugee solutions. So it's a complicated matter, but it's not rocket science.
I'm just interested in implementation for one moment.
Sure.
One of the positions put by Israeli jurists is that if they dispute for various reasons the right of return, but they say even if you did implement the right of return, it would effectively lead to the destruction of Israel, and that's one of the positions put. Do you support a two-state solution? Do you support a one-state solution? And what is your position on UN Security Council Resolution 242?
So I do have a preference, but what I'm most interested in is compliance with international law, and I'll tell you why. Because the Palestinians are the largest refugee population, outstanding refugee population in the world. Second is Tibetans, and then Western Sahrawi. And there has been a concerted effort by the international community, advocates for refugees, international human rights lawyers, lots of folks, over the last 60 years to preserve and build this body of law that protects the rights of refugees. If it's all thrown out on the backs of the Palestinians, we start from square one. So the consequences of what happens with this refugee population are well beyond this particular case. So having said that, my main concern is that these principles be respected, at least in the main. Now, refugee return, property restitution, compensation can all happen in any configuration of territory. We have seen refugee solutions where there have been successor states and refugees have been able to go back to their homes regardless of which side of the territory they came from. We have found, for example, Dayton, the main thrust of the Dayton Accord was reversing ethnic cleansing. And so there we saw these secondary property rights, very critical and built into the agreement. So refugees who have felt they could not return to a place where the ethnic nature had changed, they were given back the title to their property, and they could rent their property, they could sell it, they could do whatever. In Dayton, not a single penny of compensation has been paid because the driving principle was reversing ethnic cleansing, returning, restituting property. So we see many different, every refugee post-conflict solution has a different character. And so, there's different ways that these can play out, but my main point is that it doesn't matter whether it's two states or one state for purposes of realizing and implementing refugee rights. Palestinians could return in certain numbers. If we play out the precedents from other refugee flows, we see that some generations, often the older generation, wants to go back. Second generation wants to stay but have their property returned. These can all be adjusted. Secondary occupants can have residency rights, occupancy rights, but the title returned to the original landowner. So my answer is.
Specifically, the issue is 5 million. I think UNRWA.
So, but that's a misnomer, because I mean that's conflating something that doesn't happen in reality. The point is, once it's driven by voluntary choice, individual refugees are going to make decisions based on many different factors. 5 million may return, but maybe 5 million want their property back, but want to stay where they are. The point is that if the law is respected, the other competing rights can be accommodated. We have enough bodies of law to accommodate. This is nothing new, is what I'm trying to say. What I can't stand about the way the Palestinian case is so often framed is that it's talked about as an exceptional case, as if somehow it's so outside of all of this law that we have that is applying every day. Once conflicts are resolved or getting over, these laws are being applied every single day all around the world. Why is the Palestinian case different? They don't have horns. Okay, my soapbox.
Just as an adjunct to that, or as a corollary, indulging the two-state framework here for a moment. Now, if in a final status agreement there were a solution in which voluntary choice were respected, what would be left to negotiate between Israel and the PLO in terms of compensation, in terms of whether the response, an acknowledgement of responsibility, or an acknowledgement of suffering, or maybe you can elaborate a bit more on beyond the question of choice, of repatriation, resettlement. What else is left to be?
All of those issues.
Sure.
All of those issues, and property is going to be. It's a huge piece of the resolution. The acknowledgement that all of this refugee property that was starting from the first absentee property law, 1950, where property was moved, 90% of Palestine belonged to Palestinians, and no more than 7% belonged to Jews at the time of partition. Today, that is completely reversed. And it has been reversed through very deliberate legislation that has removed all right and title to the properties of Palestinians and removed them in perpetuity, so that property now belongs primarily to the Bank of Israel lands and can benefit Jews only. So that has to be dealt with. Discriminatory legislation, nationality legislation has to recognize equal rights of all people. And by the way, it's no longer in Israel just Palestinians and Jews. There are an awful lot of people in Israel who don't belong to any of those, who also need to have equal rights. So the benefits of that will go well beyond these two communities. But there are a huge cluster of issues that will have to be part of the final resolution. But again, we have agreements all over the world. Afghanistan, Rwanda, Mozambique, Ethiopia, Guatemala, all of the agreements that came out of Sarefka, the Central American Comprehensive Plan of Action, all of them have incorporated very specific principles and rights. And we can do it.
I have a question about domestic situation and what obstacles do we have here in the United States for the stateless Palestinians who are stuck in limbo here, and what is your estimated number of how many people need help? And maybe during your practice as a professor in clinical research in Boston, how many people did you personally help to obtain a path to citizenship and get rid of statelessness?
It's a really good question. First of all, network of organizations have been trying to get the actual numbers of Palestinian stateless persons from the various immigration agencies for a long time and can't get actual documentation of what that is. And the reason for that is that Palestinians are ascribed to citizenship or nationality status, believe it or not, from the last place they came from. So Palestinians will be called Jordanians, or they'll be called Syrians, or they'll, even though they aren't citizens or nationals of those states, they'll be ascribed to those areas. So for that reason, we have a lot of trouble trying to get some handle on what the numbers are. I have won some Palestinian asylum cases. I have not won a lot of Palestinian asylum cases. And I have had some very heartbreaking cases where Palestinians who've lived in this country for over 2 decades have been removed and their families separated because children were born in the United States who are US citizens. Palestinians sent back to wherever.
Where?
My most recent to Gaza, even though they had no documents and no right to go to Gaza.
It's a legal thing to send people.
No.
So why it's happening?
Because the US has a lot of clout. And so we have had cases where families now are separated forever.
So what is the best solution, in your opinion, to stop this practice? Because it's human rights violation
Well,
made by US.
yes, well, there's a lot of education. So the interesting thing in the US has not incorporated Article 1D into its refugee law. So we have only the individual definition of refugee, which always fails the Palestinians. Because to what country can they be ascribed persecution? The US will always look to the last country, but that's not the country of persecution, Jordan or Syria or... So their claims are so much more complicated because of the multiple displacement and because the original persecution, which is from Israel, is never seen as the persecutory state in US asylum adjudications. What can be done? A lot of education. You guys going out there and educating everybody you know and talking to your congresspeople.
At this point, should United States join the Convention on Statelessness?
It would be
And why it's important?
It would be wonderful. We actually argue in some of our cases, and I do Tibetan cases, which have some similar problems on the stateless question. And many Tibetans come from India, from the settlements in India. So it's similar in the sense that it's the statelessness that's the issue, although the circumstances are quite different. And the US has developed jurisprudence that is very much on track with the 54 Convention on the Status of Stateless People. But it's not a substitute for ratifying the 54 Convention. I would say there's another convention, the 1961 Convention on the Reduction of Statelessness, which is a much more important treaty and has very few ratifications outside of Europe. So what needs to happen? That's the one that has a principle in it which requires a state in which people who are otherwise stateless are residing, places an obligation on that state to grant them status. That would be phenomenal.
Is it possible in the near future to make it happen, to join both conventions? Or
We have to, the US has to ratify the 54 Convention first before there's any discussion about the 61.
You know, I realize now that I have a little bit of cleanup work to do, and since we're cramming multiple semesters of instruction into a 60-minute lecture, maybe we need an explanation first as to why the descendants of Palestinian refugees, original refugees through the male lineage, are themselves considered refugees, and also why Palestinians who have Jordanian citizenship have not had their refugee status extinguished by virtue of obtaining Jordanian citizenship.
Okay, so subsequent generations, the Resolution 194 and Article 1D working together basically stand for the proposition that until the durable solution in paragraph 11 is met, Palestinians remain as refugees as an entire population. So that's a really important piece to understand the intergenerational recognition. That's their legal status under international law. And that's consistent with other refugee law, which allows family reunification, meaning subsequent generations, and that until there's a durable solution, if there's a family and more people born, they remain refugees until their situation is resolved. 2252 recognizes the 67 displaced also as refugees, and they would fall again under that 194(1)D definition. So from an international law point of view, until that durable solution is met, Palestinians as an entire population who trace themselves back to the territory, back to that 1924 legislation, they all remain refugees. Having said that, it is not inconsistent necessarily with claiming the rights that flow from being a refugee, restitution, compensation, and even return, not necessarily as a refugee, but the post-conflict basis of return, to having another citizenship. It's not inconsistent. And people everywhere in the world have dual citizenship. And it doesn't prevent them, if they have property claims in one of the places where they have citizenship, from making those claims. So this is also not really a huge problem.
What happens to the refugee camps in 30 years if people are still there? And kind of what are the steps, like, I know it's a long way off, but we're two-thirds of the way there.
So practically speaking,
Yeah,
nothing will happen. Because of the camps in the West Bank, I believe there are 17, of which 13 are either in areas A and B, so areas under full Palestinian civil jurisdiction. And the Palestinian Authority is not going to evict refugees from their shelters. UNRWA doesn't own the land in camps. UNRWA is some of the land for camp installations, meaning the camp services offices, the schools, the health clinics, whatever, it is leased, okay, from the government of Jordan. The land officially is put at the disposal of UNRWA for its use. And shelters are not, contrary to the popular imagination, shelters are not owned by UNRWA, nor are they owned or leased by the beneficiary either, right? It's confusing because UNRWA has in the past issued building citations and permits for camp improvements, and UNRWA does have a infrastructure and camp improvement program which is meant to improve the habitability of shelters, but it doesn't mean that UNRWA in fact is the lessor or the lessee of the shelter itself. Practically speaking, nothing will happen on that land. For the camps that are in Area C of the West Bank, or in the case of the Shufat refugee camp in East Jerusalem, the only camp that is in Israeli-defined municipal Jerusalem. Again, I don't see Israel picking that fight with the international community, trying to repossess camp lands. UNRWA post-67 operates in the West Bank and Gaza with the consent of the Israeli government through an exchange of letters between the UNRWA Commissioner General at the time and the Israeli Foreign Ministry. Israel doesn't want to assume responsibility for the health, education, and welfare of the Palestinian residents and the 800,000 Palestinians and the refugees in the West Bank.
Although these agreements between, or that the UN states or puts are supposedly binding between two parties, they're not forcible because the UN doesn't have any power over the countries that it puts these rulings between. Do you think that the solution of the problem between Palestine and Israel is going to be through law, or is it going to be more radical movement or social movements or any other kind of movement?
So law is a tool. It's
If it's not forcible, how can you make sure that it's? And we can see from the history that it wasn't carried out. They didn't take these things into account. They didn't take all the clauses or all the parts of the things that were written into account.
So, a couple ways to answer that. First of all, the Refugee Convention and Protocol each has a provision that allows states to take other states to the International Court of Justice for violations of the refugee law. Now, Israel's actually a party to the Refugee Convention, but who's the state that's going to take that case? At the same time, we have a ruling from the International Court that particular UN agencies that stand in the shoes of certain people, which would be UNHCR, for example, are authorized to also take claims of violations to the International Court of Justice. So we actually have a couple of avenues through which a case could be taken to the International Court. It's not that there aren't implementable mechanisms or monitoring mechanisms or enforcement mechanisms. Who's going to take them, and what states are going to be behind the enforcement of any judgment? In 60 years of this conflict, we've had one decision out of the International Court, and that's the advisory opinion on the wall. Now, why is that? If we look back at, I've done some work comparing some other cases where there's been denial of self-determination, and how have those cases been sort of articulated in international fora. One of the most interesting ones is Namibia. Namibia fought its battles through armed conflict, through civil society mobilization, through very sophisticated use of law, for advisory opinions and a contentious case at the International Court of Justice, which basically solidified the obligations of the rest of the world to place sanctions on South Africa, which were the final changing factor in self-determination for Namibia. It's in many ways very parallel to Palestine, but the Palestinian leadership has not used law in any meaningful way. So I come back to law as a tool. It's a very powerful tool, but only if people understand it and know how to mobilize around it. Some civil society groups have become much more sophisticated in articulating the legal rights of Palestinians, but this is very late. In fact, looking at the Palestinian refugee case as a legal case has only been post-Oslo, very, very late. And the Palestinian leadership, as I told you, my own experience, their position is law does nothing for us. Well, maybe you should try it. Nothing else has really worked.
If I can elaborate on that, the case of Namibia is interesting. So we have, 5 minutes? I won't go into the full history of Namibia, but basically the same League of Nations mandate system that gave rise to British rule in Palestine gave rise to South African rule in Namibia. And when the nationalist government in South Africa came into power in 1945, it extended apartheid also to its mandated territory, Namibia. Okay, and again, through, as Susan mentioned, several advisory opinions and a contentious case. Ultimately, the General Assembly terminated the mandate that South Africa had for Namibia. But South Africa didn't quit the territory of Namibia, and there was a Security Council resolution as well that South Africa did not comply with, did not quit Namibia. And so the case taken to the ICJ for an advisory opinion is the legal consequences of Namibia's refusal to comply with the Security Council resolution, confirming the termination of the mandate and demanding that South Africa abandon Namibia. And the case held that South Africa's continued presence had the status of an illegal foreign occupation. Okay, and the court identifies a doctrine called the doctrine of non-recognition. Okay, now the substantive content of that document was not fully articulated in the case. There were several separate opinions, but basically what is clear is, one, that a foreign state can't have diplomatic or consular relations with an illegal regime. Okay. Secondly, that any application of a treaty between a third state and South Africa had to disclaim its applicability to Namibia. Okay, but that third states couldn't deny recognition to ministerial acts that didn't have any implications for recognition and denying recognition to them would only harm the local inhabitants, right? So birth certificates, death records, etc., right? You had to keep honoring those, and you could not maintain diplomatic and consular relations, and you could not apply your treaty obligations to Namibia. But in between those two poles, there's a huge lacuna of content there, right? That really hasn't been filled in the intervening, whatever, it was 1970, so in 45 years since, right, this lacuna really hasn't fully been filled. And although I agree, broadly speaking, that Palestine has not pushed law as hard as the Palestinian National Movement hasn't pushed law like it should, okay, you see a bit of evolution of that in the 2004 ICJ advisory opinion on the wall, where the court said that all states have a duty not to recognize or give effect to the illegality resulting from the construction of the wall and its associated permit regime, okay? And more recently, you see measures like the European Union's guidelines on settlement funding, funding for settlement-based enterprises or activities conducted in settlements, right? Which takes a quite robust interpretation of that duty of non-recognition. And so Susan is right. You can see some linearity between Namibia and other, other decolonization contexts like that and Palestine. There is a big push now in the academic world at least, for an ICJ advisory opinion on the legal consequences of the Israeli regime in Palestine, which has elements of apartheid, or racial segregation, right, and an annexatory character as well, right? The annexation of Jerusalem, the de facto annexation of area to the west of the separation wall, for instance, and there's a push to do that so far that has fallen on deaf ears within official Palestine, much to the chagrin of lots of legal academics.
I'd like to thank the panelists for, especially Professor Akram for coming all the way from Boston. And thank you to all of you for sticking around for so many hours. The reception is back where the first panel is.
We did, yeah. I kind of